are on the application of AAA, HCN, RM, AS, SAA against the Secretary of State of the Home Department.
Yes, Sir James.
Well, good morning. I wasn't planning to go through the cast list, not least because it would take about 15 minutes to get through it all. And I'm assuming that you have that and that you have the rough order in which things are going to be done by way of submissions.
Yes.
I'm scheduled, I think, to go till 3 o'clock this afternoon. I've said to my learned friend, and he's content, if I go a little bit over that, then it will come out of my reply and response on the morning of day 3 or the afternoon of day 2.
Yes.
So probably 3 to 3:30 will be me done, if that's acceptable.
Yes, of course. Can I ask you, Sir James, are these proceedings being transcribed? Do you know?
I don't know, I'm afraid. They will be recorded in the usual way, I'm assuming, so,
Yes.
but I don't know whether there's a transcription.
Sometimes parties have a transcription, in which case we don't need to take as full notes.
I haven't heard of any private transcription.
No, that's fine.
I'm getting shaking of head, so I suspect it'll be the live recording or bust on that. My Lords, the context for the appeal, as you will be well aware, is a policy to which the government attaches considerable importance. There is a serious and pressing need to take effective steps that will act as a deterrent to those undertaking the perilous and sometimes life-threatening journey, typically across the Channel from a safe country, normally France, very often facilitated by people smugglers and criminal gangs for money. And there is, we submit, a strong public interest in that legitimate, indeed key policy aim. Despite earlier arguments in this litigation to challenge that base policy position, there is now no remaining challenge to it as a base policy. So that base position and its justification are the starting point. The remaining question, which is for my Lords, is whether the second limb of that policy, to remove to a country less attractive to the cohort than the UK, but nevertheless safe, is lawful. You have seen the myriad grounds of challenge, including the range of public law grounds, most if not all of which have dropped away, leaving for my Lords, subject to the discrete EU law point, simply the HRA challenge in its various forms, particularly to refoulement, and then by way of further permission from this court in relation to the conditions in Rwanda and the procedural issues arising under the HRA through the Ilias case. So that's the broad scope of the debate. And the key question is whether there are, to take the test which is very well known from Suring, substantial grounds for believing that there would be a real risk of ill treatment for any person removed under the arrangements between the United Kingdom and Rwanda. The appeal we submit is at heart about the judgments made by government as to the future conduct of a friendly foreign state, Rwanda. I emphasise that at the outset because Rwanda is, we submit, a respected sovereign state. It's signatory to the Refugee Convention, it's signatory to UNCAT, the Convention Against Torture, and it is a member of the Commonwealth. Those judgments made by this government were made in circumstances in which both our government and the Rwandan government were fully aware of the likely controversy of the arrangements that were made. That fact, indeed, was a significant driver of the detail of the arrangements that were put in place and agreed between the United Kingdom and Rwanda. And the challenge, as the Lord Chief Justice in his dissenting judgment rightly recognised, is to the ability of the UK under these arrangements to remove any single individual to Rwanda. And it is plain Rwanda can comply with those commitments, devoting the time, resource and will that may be necessary to ensuring that that occurs. That's why I say that this case is at heart about a governmental judgment about whether it will do so. And I wanted to start these submissions by introducing, at least briefly, given the comprehensive nature of the judgments that you have seen below, the nature of those arrangements before coming directly to the appellate issues. So the arrangements, first of all, and I wanted to make 5 short points by way of introduction to those, and I'll expand the 5th one in a little bit more detail. First of all, this is a bespoke scheme with a very clear and expressly agreed aim. The fundamental purpose of the MOU, the Memorandum of Understanding, and the Note Verbal, the NVs, which together make up what's called the Migration and Economic Development Partnership. You've seen references in the paper to the MEDP. The fundamental purpose of those arrangements is to provide assurances that will enable and secure the safe transfer of individuals to Rwanda for the processing and determination of their asylum claims in accordance with the Refugee Convention and ECHR guarantees. One sees those objectives very clearly spelt out in the Memorandum of Understanding itself. My Lords, at paragraph 2, I'm going to give you, I'm afraid it will become increasingly a series of references, but can I simply give you the electronic page number? I'm going to go to some of the, try and do quite a lot of it by reference to the judgments below, which are in the key file. So by and large, if the number's got 3 digits, it's in the key file. If it's got 4, it's in the core file, which contains all the authorities as well. So in relation to the MOU and the confirmation of the objective of these arrangements, paragraph 2 is, it starts at 2362. And the page I want is 2367, where you will see the objective specifically identified at paragraph 2.1 of the MOU on page 2367. If you could just cast your eye down that to refresh your memories of that. And in order to achieve that objective, everything else follows. Everything in the MOU, everything in the Note Verbal, a series of key safeguarding elements specifically built into the scheme and specifically committed to by Rwanda. That's the first point. The second point is that those arrangements clearly and carefully set out the numerous and detailed commitments designed to deliver that aim, as was noted by the Divisional Court in its judgment at paragraph 65. The care with which the scheme and the commitments were considered by both governments is evident from the face of the arrangements and indeed from the description and the evidence of the processes that led to them. There is nothing doubtful or difficult, we submit, about what they mean or what is intended by those arrangements. The judgment is about whether or not Rwanda will comply with them. They are detailed assurances from Rwanda regarding both the processes that are going to be put into place for determining the relocated individual's asylum claims and governing both the reception and ongoing treatment of those individuals when they are in Rwanda. That's why you have references to the process note verbal and the accommodation and reception note verbal, where the detail of that is contained. The core elements of the MOU and the NVs is perhaps best found in the Divisional Court's judgment between paragraphs 18 and 27. Just for your reference to locate the Divisional Court judgment, that's in the key file at 392 and following. So you have that there, and we've summarised those key provisions, also a case between paragraphs 57 and 73. And I make the point specifically because it's important. The assurances we submit are ex facie sufficient to avoid any real risk of an Article 3 kind, as the Divisional Court found in the second half of paragraph 62. That's the second point. The third point is that it is a scheme which we submit falls to be judged in its own context and on its own terms. There has been very considerable debate, as you will have seen, about Rwanda's conduct in the past. and it is evident that there are significant issues about that. We submit that they can't simply be assumed to be well-founded. There are a series of issues between, in particular, the UNHCR and the Rwandan government about that. But it's also evident that the UK cannot possibly seek to resolve those issues. It's in no place to do so, practically, or in most cases, even possibly. That does not mean that those concerns having been raised are to be ignored. Quite the contrary. They have been and were considered and taken into account as an integral part of designing the protections that the UK should invite Rwanda to commit to as part of the new bespoke arrangements. And you then have to make, if those commitments are given as they have been, a judgment about their willingness, good faith, and commitment to making those arrangements work. The key point for this purpose is that whatever debate there may have been, or may not have been, about Rwanda's conduct or record in the past, is, we submit, at best peripherally relevant. This is a new context with a new set of detailed arrangements that have been committed to by Rwanda and the UK, in significant part with those concerns in mind.
Sir James, am I correct in understanding that what is created is not a parallel system, but is the use of the existing system with superadded assurances?
My Lord, I think that's right in its essentials. You have got the existing system, but with those guarantees grafted on, and with ongoing discussion between the governments as to how that system is intended to work. And I'll come to the detail of how the thing is set up in due course. But my Lord is right. This isn't a parallel system. It draws on the existing one, unsurprisingly. But with those commitments in place. I emphasise that as an add-on to that. If you wanted a reference to the fact, in the evidence, the fact that the structure and those commitments were designed not merely to assure the processes going forward, but also to deal with the concerns of the past, you have it in Mr. Armstrong's first statement at paragraph 16, Roman 2, at page 2655. The fourth point is that the practical incentives to compliance by Rwanda with the detail of those commitments are very powerful. And by practical incentives, I refer to things in addition to the fact that a friendly foreign state, a member of the Commonwealth, as I've said, has committed itself and can be expected to comply with its commitments on that basis alone. There is a strong record of the UK working effectively in the context of existing development partnerships with Rwanda. See Mr. Mustard of the Foreign Office's statement at paragraphs 3 to 4 and 8 to 9 at page 2742. There are obvious and significant reputational incentives. The Rwandan government is entirely well aware, and has been from the outset and is now, of the controversies and the critical importance attached by the UK to all parties making that scheme work and work properly. Rwanda knows full well that the United Kingdom expects compliance precisely to ensure that the objective that both parties identified in the MOU at paragraph 2.1 is delivered in practice. So this is not merely a situation in which serious commitments have been made on the international plane. Those serious commitments will, to the knowledge of all, be critically and minutely scrutinised, and the reputational consequences of non-compliance or a failure in the arrangements would be very serious for everyone. That was indeed the clear view of the Court of Appeal. Even at the interim relief stage, you don't have that judgment in your bundle, but they made the point strongly at paragraph 95 of that judgment that the UK, as they put it, will expect Rwanda to comply with them, that is the commitments, and the Rwandan authorities will know that their conduct will come under scrutiny in the particular context of people who've been removed there by the UK pursuant to the arrangements between the two countries. The point made at the interim relief stage by the Court of Appeal, that stage culminating in this court. There are, in addition and if necessary, pretty strong financial incentives to ensuring that the commitments are adhered to. That was a point that the Divisional Court noted in particular at paragraphs 25 and 26, with their conclusion on the issue at 65 of the Divisional Court's judgment. The references in the evidence to the funding arrangements referred to in paragraph 25 of the Divisional Court's judgment are Armstrong 1, paragraphs 16.3, 16 Roman 3 and following at 2656. And we've summarised those arrangements, I hope adequately, in our case for you at paragraph 83.2. Very significant sums overall, and they get grants of funding, or more funding as it were, for all those who are processed, and additional funding if refugee status is granted, along with a guarantee of 5 years residence in the country if that is the outcome of the process. The fifth point, which I said I was going to expand a little bit on, if I may, is a point that the Lord Chief Justice, as you will have seen from his judgment, attached very significant importance to, which is that the scheme will be carefully and independently monitored. References for your note summarising the nature of those arrangements. See our case between paragraphs 90 and 100, and see the Lord Chief's judgment in particular at paragraphs 501 to 509 in his judgment. And I wanted to spend a little time on this, especially because of two reasons. Firstly, this is, we submit, a very important factor in principle applying the Othman test, which I will come to in due course. See in particular, I'll come back to Othman, so I'll just give you the reference now because I'm going to come back to it. Othman, paragraph 189 sub 8 at 7520. That makes clear the importance of this factor when considering the reliability of assurances in the context of the risks of asserting ill treatment allegation. And secondly, important to spend a little time on this because these monitoring arrangements are, as the Lord Chief pointed out at 463, para 463 of his judgment, they are, in his words, designed to ensure that Rwanda deals with asylum applicants appropriately with no relevant risk of refoulement for those with valid claims. So the claimant's case in this litigation necessarily involves the proposition that they will be ineffective, that those monitoring arrangements will be ineffective in that design with that intent. There are three levels of formal monitoring to note under the MEDP. They're set out in our case at paras 90 to 95. The British High Commission in Kigali, with Home Office officials embedded to monitor that compliance, an independent monitoring committee for which the MOU makes provision, and the committee for which the MOU also makes provision. And those three formal arrangements, which I'll come to in a second, are in addition, it's important to note, to the practical monitoring, which was noted by the Lord Chief Justice at paragraph 505. And that includes monitoring day by day, or periodically by the UNHCR and all of its offices and its critical view of the systems in Rwanda. So the British Embassy and the Home Office officials embedded in Rwanda to take that first. For the duration of the arrangements, there will be a Home Office liaison officer posted at the High Commission in Kigali. The MOU makes specific provision for that in paragraph 13.4, page 2371. The role of that officer is to develop relationships with the key stakeholders in all parts of the system, to flag concerns, and to make the MEDP work. C, for a summary of that aim and purpose of that liaison officer, Mr. Krellin's first statement, C-R-E-L-L-I-N, first statement, paras 4 to 14, at page 2735. And as he points out at paragraph 8 of that same statement, the liaison officer is going to be supported on the ground in Rwanda by a Home Office operational lead, the Immigration Enforcement Liaison Officer. And those individuals have a right, making their oversight and monitoring practically effective, they have a right under the MOU to observe any stage of the asylum process. See for that purpose paragraph 13.5 of the MOU, which says, in order to facilitate coordination under this arrangement, respective liaison officers deployed by Rwanda and the UK under 13.4 will be allowed in the operational process in both the UK and Rwanda, including the screening of asylum seekers. So that's the structure on the ground, and all of that is backed not merely by that right enshrined in the MOU to oversee and have access to all parts of the process. It's backed by specific information provision guarantees or safeguards. In particular, Rwanda will provide a quarterly report to the UK on the outcome of each and every asylum claim and appeal, the status of each relocated individual in Rwanda, and the details of anyone, any single individual who has left or been removed from Rwanda. See for that purpose Armstrong 1, paragraph 16.9, Roman 9, and 61 to 65, the page reference being 2658, and see also the operational NV at paragraph 6.2, page 2395. The degree of access which the Home Office have already been given and the closeness of the cooperation that has already taken place in practice is again dealt with in the evidence in the statements of Mr. Williams, 2706, Mr. Krellin in his first statement, 2734, and in his second statement, 2748. Note also that there is to be an IT tracking system providing a strong audit trail in relation to each and every case flowing through the system. That is evident from the Home Office internal report summarising meetings with the Rwandan officials on that subject. The page number is 3183. I don't propose to invite you to turning it up. It says in relevant part, the recording of decisions will be stored digitally on a bespoke asylum IT program. The government of Rwanda confirmed the digital system has been in place for a number of months. Individuals will be easily identifiable in the process by having a unique reference number which will enable a strong audit trail which will capture the dates and details of key decisions. So the key points at this stage, even in relation to this first element of the formal monitoring, this is, we submit, a proactive monitoring mechanism which is on the ground from day one. And as the Lord Chief put it at paragraph 505, in his words, this enables the UK to monitor on a constant basis that the assurances are being met and the system in Rwanda is working. It also provides accountability by the government of Rwanda to the UK for the assurances given under the MEDP. In addition, and still sticking within the Home Office, there is, as you will have seen, a team back in London, as it were, which itself is overseeing these arrangements. There is a thing called the Country Policy and Information Team, the CPIT, in the Home Office, providing another strand of monitoring and/or protection. And they are the team that produce the Country Policy and Information Notes, to which you may have seen reference, the CPINs. And those CPINs are reports that are kept under review. They're revisited on a regular basis with a view to ensuring that caseworkers have as up-to-date set of information as possible about the status of things in Rwanda. See for that purpose Armstrong 1, paragraph 29, 2663 is the page reference. And of course their findings, as Mr. Armstrong points out in the previous paragraph, paragraph 28, were a critical element in identifying the areas of concern that were then factored into the negotiations with Rwanda and were used to inform the design and the drafting of the assurances that were then secured in the documents that I've taken you to, the MOU and the NVs. So that's the first strand of formal oversight within the UK government. There is then, on the ground in Rwanda, and provided for by the MOU, an independent monitoring committee. It was noted, its function and its existence were noted by the Divisional Court in its judgment at paragraph 23 and then relied on in its reasoning at 65. The aim of this mechanism is described by Mr. Armstrong in his first statement at paragraph 16, Roman 8, page 2658. And then again in the paragraphs that follow paragraph 73 in that same statement, 2679 and following is the page number, including access being guaranteed to all parts of the process through the MOU for the Independent Monitoring Committee. The reference to that in the MOU is paragraph 13.2. And the basic structure is that information gathered by the Monitoring Committee and its recommendations will then be used by the Joint Committee, as it were, which sits above it, the more intergovernmental body. The Joint Committee sits above it to identify areas for improvement and remedial action in relation to any part of the end-to-end relocation process, and indeed to inform future planning on timing and future planning on volumes of individuals relocated in this way. See for that purpose Armstrong 1, para 77. So the MOU, if you have that on screen, the MOU at 2371, page 2371, you will see paragraph 15 entitled Monitoring Committee, and it essentially provides for the formation and indeed for the independence, see para 2, of that monitoring committee. Its remit and the access that it has are provided for in 15.3.2, monitor the entire relocation process from the beginning, and 13.2, which I mentioned a minute ago on page 2370. You see that at the bottom of page 2370, granting them access to make an inspection without delay. No need to have prior notice of a visit or anything else. They can simply turn up and inspect. So practical mechanisms to ensure their effectiveness as well as their independence. The process by which members of that monitoring committee were nominated and appointed is dealt with in Mr. Armstrong's fifth statement. See page 2763 to 2767. I don't need to go into that statement. It sets out the specific names of the UK membership and the Rwandan membership of that monitoring committee, distinguished people, including an English silk, Harry Salve KC, but a distinguished range of independent people. The names and profiles of those individuals, if you want to see them, are at 3442 in the electronic bundle, but suffice to say they're both distinguished and independent. The terms of reference for the monitoring committee have also now been set out. See for that purpose page 3447 to 3450, and they set out that the conditions that the monitoring committee will report on will include, as it's put, the initial screening, the reception conditions, the accommodation, the processing of asylum claims, the treatment and support of relocated individuals at all times. And the terms of reference then at page 3449 set out the minimum things that the monitoring committee, and they emphasise that they're minimum things that the monitoring committee will be undertaking and expected to do, including, for example, attending the RSDC meetings. That's a key part of the process, or hearings, a key part of the process in determining the asylum claims, reviewing a sample of complaints, if there are any, and interviewing transferees to the extent they consider it appropriate. Their formal output is going to include a written report to the Joint Committee every quarter for the first 2 years. See the terms of reference at page 3449, and a summary report for publication annually. See page 3449 again. And the terms of reference are themselves, just in case they needed tweaking, subject to review every year by the Joint Committee. See page 3450. So that's the monitoring committee. Then the Joint Committee is dealt with, in particular by the Divisional Court in their judgment at paragraph 22. If you still have the MOU open, if you go back to page 2372, you will see that paragraph 21 is entitled Joint Committee, and it sets out some provisions in relation to that. The UK representatives are the British High Commissioner in Rwanda, a senior operational director from Immigration Enforcement, a senior member of Home Office Legal Advisors, Christian Armstrong, who was the person who produced the statement I keep referring to, who's the head of the Third Countries Asylum Partnership Task Force in the Home Office, and the Rwandan members of the DGIE, MINEMA, and the Foreign Ministry. See that both Armstrong 1, para 62, page 2676. The functions and purpose of the Joint Committee are set out in the MOU, as you see, at paragraph 21.2. And you will see a provision for its first meeting at paragraph 21.3. In fact, it first met in Kigali on the 31st of May 2022 to discuss preparations for what was anticipated then to be the initial flight from the UK. See Armstrong 1, para 61, where he says that both participants at that meeting agreed to work together to share expertise, to build capacity where needs were identified, and gives the practical example of interpreters, where there was discussion about the adequacy of the provision of interpreters, and matters were agreed in relation to that. The terms of reference for the Joint Committee have also been agreed, as Mr. Armstrong points out at paragraph 62. If you want the terms of reference themselves, they are to be found at page 3435 to 3459. And under the terms of reference, perhaps the point of most note is that the Joint Committee are responsible for ensuring, inter alia, that the terms of reference for the Monitoring Committee and the process for ensuring that the Monitoring Committee has unfettered access for the purposes of completing their assessment and reports is adequately dealt with. And as we've seen from the earlier references, one of their functions is to make sure that there is clear and focused discussion on the plans for the number of individuals over the years to make sure that the system can cope with whatever volume is of individuals are relocated to Rwanda for that purpose. So the key points on all of that in relation to independent monitoring and informal monitoring is that there are assurance mechanisms. They are proactive. They are supported by all the things that are needed to make sure that they are practically effective, including information provision and giving access to the various parts of the system that will be monitored. They will be on the ground from day one, and they will work from before then, given that everyone, including Rwanda, will be well aware that there will be close scrutiny from the very first case. Taken together, therefore, we submit they provide a form of constant monitoring designed specifically to ensure that the terms of the arrangements will be honoured, and if there are any problems, they will be picked up and rectified. And when I say the terms will be honoured, I mean the terms will be honoured including trying to ensure that the overarching objective that you saw at paragraph 2.1 of the MOU is indeed met and complied with. And in those circumstances, we submit it's unsurprising that both the Divisional Court and the Lord Chief Justice place considerable reliance on this oversight and monitoring. See for that purpose in particular para 65 of the Divisional Court's judgment and paragraph 509 in the judgment of the Lord Chief Justice. Two final points to note on this aspect. Firstly, there is assurance in the MOU, as you will see from paragraph 11 on page 2370, for the returns of relocated individuals to the United Kingdom. Just invite you to note that, page 2370, paragraph 11. There is also a complaints mechanism provided for within these arrangements, and for that purpose, can I just invite you to locate the process, what I'm going to call the process note verbal, which starts, in substance, starts at page 2379. So 2379, and the paragraph I want for present purposes is paragraph 10. If you wanted detail, not sure it's necessary, but if you wanted detail on the precise way in which the complaint system is going to work and the procedure for it, it's one of the things that people have to be told about on reception as soon as they arrive. But if you want a detail of how the complaints procedure works in practice, or is going to work in practice, see 3267 and 3270. And you will recall that one of the functions of the monitoring committee under its terms of reference is going to be to review at least 10% of the complaints that are made, if any, including a sample of serious incidents. See for that purpose page 3449. So those are the 5 core points I wanted to make by way of introduction in relation to those arrangements. I was then going to turn, if I may, to the approach in principle to the Suring and Othman law. And I start for the purposes of this analysis, the approach in principle analysis, with 4, as we submit them to be, critical facts. The first will be evident from the submissions I've made already. A friendly sovereign state has chosen to enter into a series of commitments safeguarding treatment, both in terms of processes for determining asylum claims and in terms of treatment whilst in Rwanda for any individual transferred under these arrangements. And the starting point we submit is thus the starting point, the well-known starting point from Yogathas, Yogathas, which you'll be very familiar with, paragraph 9, page 4614, where the House of Lords said the Home Secretary and the Court should not readily infer that a friendly sovereign state which is party to the Geneva Convention will not perform the obligations it has solemnly undertaken. Secondly, it's an important point, there is no real criticism of the arrangements made in the MOU and the note verbal.
I'm sorry, Sir James, could you give us that page reference again?
Yes, I hope my note hasn't gone awry. I've got 4614.
No, I had written...
Lord Bingham in your reference. I'm so sorry, I may have misspoken.
No, thank you.
Do you have that as Lord Bingham? For the appellate
Yes, got
committee,
that.
thank you. Second point, no real criticism of the arrangements made in the MOU and Note Verbal. The commitments Rwanda has given are designed, as we've seen, specifically to ensure, see the objective in 2.1 of the MOU, specifically to ensure that the Refugee Convention and Article 3 rights are properly protected against any real risks. And they were specifically given, as we've seen again, with the controversy in mind. But they are, as I made the point earlier, ex facie sufficient. No one points to any inadequacies in the content of the arrangements. And the consequence of that is that the question for the courts is whether Rwanda will ensure that those commitments are faithfully adhered to. And that is, at core, we submit, a question of judgment. Third critical fact, instead, a series of concerns has been raised, especially by UNHCR, about Rwanda's historic conduct and its ability or willingness to operate satisfactory systems, or the satisfactory systems, once one recognises that the commitments are ex facie sufficient, the satisfactory systems that it has committed to, taken into account in the design of the commitments, as I've already pointed out. The question remains whether, recognising those concerns, the government of Rwanda will have the will and resolve faithfully to deliver on those commitments. So the existence of those concerns does not alter, we submit, the nature of the central issue. The fourth critical fact is that, in fact, the government has considered that question of judgment and has reached the clear conclusion that Rwanda will faithfully comply and ensure compliance with those commitments and that objective, and will therefore provide the systems that they have committed to provide to achieve that end. See, for that purpose, in particular, and it is only in particular, but it comes from the Foreign Office witness, Mr. Mustard, see Mr. Mustard, paragraph 20, page 2747. Against that backdrop of fact, I turn to Othman, which is page 7462 electronically. Just before getting into the detail of Othman, I'm not going to go too far into the detail of Othman because it'll be very well known to the court, but it's important to note at the outset that at a very basic level, the European Court of Human Rights applies the headline test, which is very well known, of substantial grounds for believing that there would be a real risk of ill treatment with some real rigour. The test itself has the adjectives inherent within it, but the rigour with which they approach that question is emphasised in the authorities in the way which the Lord Chief identified in his judgment in the Court of Appeal at paragraph 492. So although it is real risk, it's a test that's applied with real rigour. In Othman itself, the European Court concluded that the deportation of Abu Qatada to Jordan would not violate Article 3 in the light of assurances given by the Jordanian government that he would be treated in accordance with the ECHR. And it is quite important to note on the facts of Othman that the European Court so concluded, despite a finding that torture of detainees was widespread and indeed routine in Jordan. And in coming to that conclusion, the European Court made clear that it would only be in very rare cases that the general situation in a country including what it's done in the past, including poor conduct, in that case extremely poor and routine conduct in the past. Very rare that that would mean that the assurances that they give cannot have weight attached to them. See for that purpose paragraph 188 in the court's judgment at page 7519. So Othman establishes as a proposition that even if there are accepted concerns about the most serious Article 3 ill treatment in a foreign state, that does not necessarily undermine the assurances. It is still possible and permissible under this test and this case law, therefore, for assurances to be provided that in effect create a break with whatever has occurred in the past. The past may of course be of interest, but what matters, as Othman demonstrates very clearly on its extreme facts, is the analysis of the present and the future in the light of the assurances that have been given. The European Court's approach is encapsulated in the paragraphs that the Divisional Court themselves quoted at 188 to 189. I hope you have that page open already. So 7519 over on to 7520. Again, I'm sure those passages will be very familiar to the court, but it may just be worth... Sorry, 187, my learned friend wants to draw attention to as well. Could I just invite you to cast an eye down those 3 paragraphs to remind yourselves of what the court there said. So you'll see the non-exhaustive list of factors set out at 189, including the one I drew attention to earlier, emphasising the importance of monitoring compliance with any assurances at sub 8 of paragraph 189. And it is very important to note not merely the nature of the difficult and extreme conduct which had been routine in Jordan in other cases in the past, but also important to note that there the particular concerns about the assurances were based on a context in which the person concerned, who was proposed to be removed, Abu Qatada in that case, was or might be considered to be a potential risk in and to the receiving state because of their connections with terrorism or extremist activities. So to put it in the vernacular, there might be in those circumstances a pretty strong incentive on the receiving state to misbehave, given the nature of that context. And indeed, in the past, as one sees from the facts of Othman, there had been serious concerns of precisely that ilk. We've got a fundamentally different context here. All the incentives are the other way, with all of the financial incentives and so on that I went through earlier. There is every reason to conclude that Rwanda will want this arrangement, this set of arrangements, to work. So the Othman factors here, we submit, point very powerfully towards the assurances being honoured. And again, we submit there was no flaw in the Divisional Court's factual analysis of the Othman factors, having set out the correct Othman test as they did. See the Divisional Court's judgment, paras 62 to 71. There is every incentive to comply, both reputational and financial. The detail of the arrangements and the assurances have been disclosed to the courts. There are specific assurances that have been given as to the treatment to be received. They are provided at a high government level. There is no history of ill treatment of any individual asylum claimant removed under the arrangements, precisely because none has happened. But it doesn't seem likely that there is going to be any axe that the Rwandan government would have to grind against anyone going through the system for the purposes intended. And the latter point is of some importance because this is, in nature, a preemptive challenge. The assurances and arrangements are, we submit, to be given full force. It is a high hurdle to suggest, as the claimants do, in advance of the operation of the arrangements or of a single instance of anything actually going wrong or being dissonant with the commitments, that they will not work. That was a point, again, that struck the Lord Chief, particularly in his analysis of the nature of the judgment, emphasising that the claimant's case was that no single individual could be transferred because everyone would be at risk. It's also perhaps important to emphasise that one can't apply an unrealistic standard. It's not necessary to establish that nothing could ever go wrong, or even that there's no prospect of any individual case being mishandled. There are instances of things going wrong in virtually every country which runs an asylum system, including, I respectfully say so, the United Kingdom and her near European neighbours. That fact does not suggest that, for example, the UK or France would not be safe countries for the purposes of Article 3. So that's the Othman case and the nature of the test that it establishes, and inherent within that, and particularly under our domestic constitutional arrangements, there is a question that arises, which is of some importance, as to the court's proper role and respect for the judgments that are made by the government. And I wanted to make 4 short points about that because this is a territory which it will be very, very familiar to the court. And so I take it lightly, not seeking to diminish the importance of these points, but it'll be familiar to the court anyway. So 4 short points. First, there is no doubt, and there never has been at any stage of the proceedings, certainly not before the Divisional Court, that the question whether a person faces a serring risk, I use that as the shorthand for substantial grounds for believing all of that, the serring risk question is a question for the court. No dispute about that at any stage of these proceedings. Secondly, there are very well established and often considered principles governing how the court goes about that task. That does not touch the first point. The decision remains for the court to judge, but those principles govern the manner in which a particular core element of assessing risk is dealt with. Thirdly, those principles, well established over a series of cases, include according particular respect for the views of government in relation to certain types of judgment call or issue. It's a respect that is accorded on constitutional grounds and also on grounds that the government has the expertise and experience that make it particularly well placed to make that judgment. And I'm not going to go back through the series of cases, you know them well: Raymond, Lord Carlisle, Begum, which I think is the only one of the sequence in the bundles, but it cites all the other cases, page 6, 5, 7, 8, if you wanted to be reminded of the Begum decision, and of course the famous passage at the very end of Lord Justice Lawes' judgment in Al-Rawi, not the Al-Rawi about secret hearings, the other one that followed on from Guantanamo Bay and all of that. But same theme, same point. That's the third point. The fourth point is that the judgment in question here, in this case, involves elements which bring the context into precisely this territory. I'll come back to how they apply here shortly, but the key features that the court takes into account in determining whether, and if so, how far one is into that territory, if I can put it that way, predictive judgments about the attitude and likely future actions of a friendly sovereign state, including good faith, but also calls about the willingness and commitment in a broad sense to acting in a particular way, if necessary, changing past approaches, tweaking existing systems, devoting the requisite resources to ensuring that new systems work effectively, all involve questions of judgment. And they are judgments we submit in relation to which the government's institutional expertise must and does play a strong part. And we submit that the Divisional Court, in its judgment in particular between paragraphs 64 and 66, were right to attach weight and strong weight to that feature. And we submit also, for good measure, that the Lord Chief Justice, relying specifically on the analysis of this court in Raymond and in Begum, was right to do the same thing. See paragraph 471 in the judgment of the Lord Chief Justice, noting His Majesty's government's institutional expertise in assessing, as he put it, the worth of diplomatic assurances. So against that backdrop, and specifically with that backdrop well in mind, I come to the first core submission on the appellate issues before this court, and the submission is that the Divisional Court did not err in understanding or in applying the Suring test. And again, we submit that the Lord Chief was correct in identifying the issue, the core issue at paragraph 479, and in concluding, as he did in a prolonged section of his judgment between paragraphs 481 and 493, he was also correct in concluding that the Divisional Court did not misunderstand or misapply the test. Compare, for your note at least, the majority reasoning in the Court of Appeal. The Master of the Rolls' relevant bit of his judgment is at 73 to 78, and Lord Justice Underhill, relevant bit for this purpose, is at 128 to 129. And we submit that the majority of the Court of Appeal did indeed fall into the trap identified by Lord Hoffman in the Piglowski case that we have referred to. I think it's probably sufficient to take it from our case where we've given you the relevant quotation as well. If you go to our case at paragraph 21.3, you will see the references to Lord Hoffman in Piglowska against Piglowski. Can I just invite you to refresh your memories of that paragraph and what Lord Hoffman said there? A strong presumption applying that approach that the Divisional Court well understood the basic nature of the Article 3 approach and applied the correct test. What instead the majority did, we submit overall, is that they applied, as it were, a minute textual analysis, focusing on particular phrases and bits of the judgment of the Divisional Court, with in effect a burden on the Divisional Court to demonstrate the application of the correct test. But in any event, we're going to submit that the analysis of the majority of that Divisional Court judgment on this aspect was wrong, and the Lord Chief's analysis of the Divisional Court's judgment on this aspect was right. The true position we submit is that the Divisional Court correctly cited, analysed and then applied the European Court of Human Rights jurisprudence in Hoffman. See paragraph 63 of their judgment. They did not simply apply a rationality review. It is evident from their judgment that they considered whether there were reasonable grounds for believing there was a real risk of Article 3 ill-treatment if the individuals were removed to Rwanda. They analysed the evidence and the material before them for themselves, focusing for obvious reasons on Hoffman, and then reached their own conclusion. Much has been said in our case, in the judgment of the Lord Chief Justice about this issue, so I take it relatively shortly, because the court, I know, will have read all of that, just to make a couple of points, if I may, on this issue. Firstly, just to reinforce a point that the Lord Chief Justice noted at paragraph 480 of his judgment. This, if error it was an extremely surprising error for the Divisional Court to have committed, given two things in particular. Firstly, the experience of these judges, as the Lord Chief noted at paragraph 480, and secondly, very surprising, because there was no dispute at all before the Divisional Court about the correct approach, and in particular about the question of substantial grounds for believing real risk under Suring being one for the court. Of course, applying, and maybe this is where the confusion came, but applying proper respect as to the manner in which the court went about that exercise, proper respect for the judgments of the government about the assurances in particular. So a very surprising error, if indeed error there was. But secondly, we submit, the structure of the judgment of the Divisional Court gives the lie to the case of misunderstanding or misapplication of that test. In other words, it's for us, the court, in favour of a pure rationality approach. You need to read, we submit, the Divisional Court's judgment fairly as a whole, rather than taking isolated, narrow parts. You also need to bear in mind that the claimants sought to mount alongside the Article 3 Suring cases in both its aspects, removal into a process which was said to be flawed, removal to a country where there were said to be real risks faced in any event, conditions in Rwanda, and the Ilias point. All of that was run together and mishmashed together with a whole series, including rationality, of other public law challenges to the safety conclusions of the Secretary of State. And we have given you the detail of that in our case at paragraph 30 to 37, including identifying, as indeed did the Lord Chief in his judgment, the way in which the Divisional Court sought conveniently to reformulate the issues before it to try and make them more intelligible and efficient. A couple of key points, if I may, on the way in which the Divisional Court approached the matter, having regard to the structure of that judgment. The first point is perhaps the critical one. It appears to be accepted that the Divisional Court applied the right approach in their judgment at paragraphs 74 to 77 when they came to deal with the precisely the same issue. In other words, substantial grounds for believing risk of ill treatment, is it a matter for the court? Precisely the same issue, but in relation to conditions in Rwanda. So when they get to 74 to 77 and that set of issues, everyone, including the majority and the claimants and everyone else, accepts that they applied the right approach. It's for them, they look at all the material, they make their judgment. And they did so, as the Lord Chief notes at paragraph 484, having broken down the issues and described the refoulement and conditions in Rwanda issues in precisely the same way. They describe both of those issues in precisely the same way, so it's exactly coincident up to that point. But it's then suggested that having adopted that approach correctly at that basic and fundamental level in 74 to 77, they then forgot about it in the earlier part of their analysis when they were dealing with precisely the same issue as it applies to the systems in Rwanda. And that, we respectfully say, is an impossible way of reading the judgment. It is not a sensible or fair way of reading the judgment. So that acceptance they applied the right test to precisely the same issue, but when it came to conditions in Rwanda, is a powerful factor that they applied the correct test when they came to deal with the earlier set of issues in relation to Rwanda and its processes. That was a point that the Lord Chief recognised correctly, we submit at paragraph 490 in his judgment. That's all the more clear, we submit, given that the content and terms of paragraph 74, making it clear that even in relation to the assurances, the ultimate decision is for the court. They use the words "we consider" in paragraph 74, and then the reasons that are given earlier are those in the refoulement section. So they're not merely applying the right test and then applying the wrong test on the majority's reasoning when they get to it earlier, but they're actually referring back, when they're applying the right test, to the earlier section of their judgment. In fact, as any fair reading of paragraphs 62 to 71 indicates, they did in fact for themselves undertake an analysis of the assurances and the various factors relied upon to seek to suggest that those systems in Rwanda would not work or would not be complied with. They did in fact do that for themselves, as is evident from those paragraphs. The references in their judgment, for example, in the Divisional Court's judgment at paragraph 43 to legally flawed, that phrase, we submit in relation to that that is evidently a reference in compendious terms to the various different ways in which the claimants have sought to challenge the safety of the Rwandan processes, which they said created the risk of refoulement. And you can see that if you go back to the Divisional Court's judgment at paragraph 43 in particular. It might be worth just turning that up very briefly. It's in the key documents bundle, so it's a 3-digit reference, and it's paragraph 43 on page 403. And you will see that that phraseology, which the majority in the Court of Appeal thought indicated, or at least part of what they thought indicated the wrong approach, as it were, but you'll see that in paragraph 43 in the 4th line. Do you see it just after the bracket? Legally flawed.
Can you give me the page number?
Yes, my lord, I'm so sorry. It's 403 in the key documents bundle.
Yes.
You may have the Divisional Court judgment also in the core, but do you have the key document?
Oh, I'm so sorry. I'm in the wrong bundle here.
You're in the core. Well, it may be in the core as well. I haven't got a cross-reference to that.
Well, I'd rather use the key, actually.
Yeah, the key is 403 then.
Yeah, thank you. Yeah.
Do you have that? Paragraph 43? I was drawing attention to the 4th line where this phrase legally flawed sits for the first time, but you see the context that surrounds it. The sentence immediately after it says this same contention is put in a number of different ways, and then it specifically splits out, as it were, the Article 3 way of putting it in A, and then various other public law grounds, Thameside and so on, in B, and then C is an irrational conclusion. So specifically drawing a distinction between the public law grounds with the well-known approach of public law courts to that. So in that paragraph, that phrase is plainly being used in a compendious way to refer to the various different ways in which the claim is put. And the various different ways, as they squarely acknowledge in that analysis, is it involves splitting out the rationality challenge as to the ECHR challenge. Again, that is subject to some analysis by the Lord Chief in his judgment at paragraph 486. The Master of the Rolls below, in his judgment at paragraph, criticised paragraph 45 and the phrase whether the Home Secretary could lawfully reach the conclusion that the arrangements would not give rise to a real risk. But that, we submit, was not an indication, particularly when read with 43 and what follows, that was not an indication that the court did not have to reach its own view on the materials when it got to the ECHR analysis. Lawfully is not, and certainly not necessarily, synonymous with rationality, and that indeed was the very point made in the permission judgment by Lord Justice Lewis, see our case at paragraph 42, And note also, in relation to those references to lawfully reaching a conclusion, the point made with some real force by the Lord Chief at paragraph 481, pointing out that to act incompatibly is to act unlawfully, given section 6 of the HRA. The Master of the Rolls then expresses concern about the Divisional Court's judgment at paragraph 62 and the framing using the phrase entitled to conclude. As to that, the claims were in effect run together, and the analysis of the issues placed them together under the compendious title legally flawed, as we've seen from paragraph 43. But the use of judicial review language, again on which the Lord Justice Underhill placed some reliance as well, does not, given the existence of the public law challenges alongside, indicate that they'd somehow forgotten that the Article 3 determination was for them. And you need to see, in fairness to them, how the analysis then does in fact play out, and how the concept of legally flawed, which they come back to later on, is then used to cover both the public law and the ECHR challenges, as is evident from the use of that same phrase that we saw in 43 when they deal with their conclusions in paragraph 71. But the key direction of the Divisional Court, it might be thought, in fairness to them, is precisely the one that they did in fact give themselves by reference to Othman, with their full citation of Othman in paragraph 63. And it is important, we submit, not to confuse the approach which the domestic courts apply to according respect to the judgments of the government in relation to certain issues that might arise under the banner of substantial grounds for believing real risk. Not to confuse that approach to recording respect, which applies as part of and isn't inconsistent with that Sering analysis in any way, with the suggestion that it might support an error of approach by the court. It's entirely legitimate as part of the court's consideration for itself to conclude that the Secretary of State was entitled to rely on those assurances and to give real weight to that, as the Divisional Court did at paragraphs 66 and 71 in particular. And we note finally on this point that the Divisional Court did not themselves consider that they had made the error contended for, and their views are, on the present case law, we submit at least a relevant factor that can be taken into account. We've given you the relevant case law in our case at paras 24 to 25, and we've given you the quote from their permission judgment and what they had to say about this asserted error of basic approach under Article 3. Paras 17 to 18 of their permission judgment is what the Divisional Court had to say about this asserted error, page 788 to 789. I think that's in the core bundle rather than the key bundle. But as I say, if one's standing back and trying to look for the critical points in relation to that, to this issue, we do submit that there is really powerful force in the idea that it just doesn't seem coherent with respect to say on the one hand in relation to a test which is identical. They got it right in relation to the second half of that when they came to consider the conditions in Rwanda, but then somehow they got it entirely wrong when they considered the self-same issue as it applies to the processes. It's the same test and the same approach, it's just a different context in which the self-same issue arises. What then are the consequences of that approach for what follows? If the Divisional Court...
Before you go there, you mentioned the Othman test in paragraph 63.
Oh, yes.
From your point of view, are the critical words contained after the quotation in the final sub-paragraph of 63, where the court is saying that the court's approach must be rigorous and pragmatic,
Yes.
notwithstanding that ultimately it is an assessment to be undertaken,
Yes.
recognising that the court must give weight.
My Lord, yes, I should have split it out because, in fairness, the quote from Othman dictates the approach under the European Convention on Human Rights. There's a slightly different constitutional issue with which this is concerned, which is what is the approach to the domestic courts. We do, for that purpose, place reliance for those reasons on the
Because that seems to suggest that in the relevant section they were
doing the rigorous analysis that they referred to and flagged up from Othman.
Yes.
Exactly so. That's the submission. But we say there are other indicators, including, as I say, the difference between the bits of the judgment.
And the problem, the language of entitlement, seems to arise out of the analysis of the claimant's submissions back in paragraph 39, I think, 39, 1 and 2.
Yes, where they've redefined the issues, as the Lord
Yes.
Chief points out.
Yes.
Exactly so. Exactly so. Well, it's a bit of a mishmash, the language of entitled to. It's a bit of that with rationality thrown in and run alongside, and it's also a bit of entitled to accord considerable respect to the judgment of the government in relation to assurances. So you've got those twin features, as it were, that feed into that phrase, which obviously appears to have caused some confusion. So in an ideal world, we wouldn't have that confusion, but it's, if I may respectfully put it this way, it's not entirely their fault. I'm sure it was our fault for getting the issues all muddled up in the way that we did, requiring them to reformulate it. But those are the points of substance that we make. I was going to come to the consequences one way or t'other, whether we're right or wrong about that. If they didn't err, then our short submission is that the Divisional Court were then entitled, after 8 days of trial, in effect, and the very careful examination of thousands of pages of evidence that they conducted, to reach the conclusions that they did. They were not wrong. The principles and the case law are extremely well known. There was precious little controversy about them, despite the number of cases you still have in your bundles, I'm afraid, but there was precious little controversy about the basic principles. And it was really a question of the analysis of the evidence in this particular context. They were not, we submit, therefore, wrong, and the Court of Appeal were not, therefore, entitled to approach this as if they were the first instance judge, because that door had been opened to them by a prior error of principle in the Divisional Court's analysis. But in any event, I've got to address the safety issues, and I've got to address the safety issues because although the Lord Chief Justice concluded as he did that there had been no prior error, he went on to consider this as if he was a first instance judge, as if there had been. You've seen that analysis on which we also rely. But also the Court of Appeal, the majority, better be a bit careful about this, Lord Justice Underhill found that, even if the court had asked itself the right question, its answer was wrong. Court of Appeal, paragraph 129. The Master of the Rolls, in fairness to him, was a little more equivocal. The Court of Appeal, in his judgment at paragraph 91, at most, we the Divisional Court was wrong to accept that the past was, as he put it, irrelevant. But even applying the Suring test de novo for himself, the Master of the Rolls then at paragraph 92 says this. He says, the balancing exercise that the court needs to undertake in making the Suring assessment I have described is multifactorial and complex. I confess to having vacillated within the decision-making process. That is, we submit, very far from suggesting that there was in truth really one and only one right answer available to the Divisional Court, so as it were, to enable it to be looked at afresh. So there's at least a question mark about how far both of those judges went, but certainly I accept that Lord Justice Underhill reached the alternative conclusion in the clear and crisp manner that he did.
Sir James,
Yes, my Lord.
if I can give you some feedback. I understand that some members of the bench would find it easier to follow your submissions if you were to refer throughout to the hearing bundle, rather than referring also to the key bundle or the core bundle.
Very well. I think all the references I'm going to come to are going to be in the hearing bundle with the 4-digit numbers, and you will have noticed that I haven't given you page references, but I've given you paragraph references into the Divisional Court and the Court of Appeals judgment. So can I take that on board and hope to comply with this? And if I don't, someone will shout at me, I'm sure. My Lords, the core second submission we make, the first submission is about whether the DC erred so as to open the door to a de novo consideration by the appellate court and the Court of Appeal. The second submission is that there is no proper basis for interfering with the conclusions of the Divisional Court on its analysis of real risk. The Divisional Court, you can put the same point in another way, was not wrong. The Lord Chief Justice was, we submit, on this point also correct for the reasons that he briefly gave. I wanted to start, and it may be that I'm chiming with what I've said already to in large part at this stage, so I'll take it briefly, but I wanted to start with a section of introduction to give you the shape of the submissions that are to come, because some of it then does get a bit detailed on the various parts of the process and where the references are to be found in the evidence if you choose to go down that road. But just to give you the shape of it to start off with, I've already made the submission, but it's important to reiterate at the outset of this set of submissions, the detailed assurances that were given are key, we submit, to the issues. They've got all of the features I've already gone through and I don't repeat. If they are complied with, then the processes and the treatment of those removed to Rwanda will be adequate and safe, using safe as a shorthand for the Serling test. I'm going to trace through the stages of the processes and pick up the concerns raised about capacity to comply with that in all its senses, including taking on the pass system and tweaking it as appropriate or dealing with changes that would be necessary. But I wanted to make 3 points at this stage about the application of the correct approach in principle that I identified earlier as an approach in principle. I wanted to apply those to the present facts, if I may, at this stage, and 3 points about that. 1, none of the detail of the responses to those concerns about Rwanda's past conduct touches that key point, that at the heart of all of this lies compliance with the assurances and the judgments that have to be made about that. And that is perhaps unsurprising as a first and opening point, because many of the concerns now raised had already been raised at the point at which these arrangements were being negotiated, and the arrangements were set in stone with a clear eye upon them. Secondly, there is no challenge at all to the good faith or the intent of Rwanda to comply with the commitments that they have given to the United Kingdom. And indeed, I can go further, there is nothing in any of the materials to base such a challenge, as the Lord Chief Justice found at paragraph 467. The clear judgment of the United Kingdom, in fact, is that that is indeed their intention, with the strong will that they will bring to bear on that and the strong incentives that they have in practical terms, leave aside reputational and honouring international commitments, to make them work to the expressed aim or end. So the case of substantial grounds for believing that there is a real risk of Article 3 ill treatment through refoulement has to be that even though there's a series of commitments in good faith, they will simply not be able to deliver. The third point is perhaps an expansion of the second. The judgment here and that has to be made, and that had to be made by the government, extends beyond good faith and intent. It applies to judgments that have to be made and had to be made about the ability and willingness of Rwanda, working closely with government if necessary, that's the UK government if necessary, to ensure that the systems do indeed deliver safety in accordance with the international standards in play. And I emphasise, everyone on both sides of these arrangements is well aware, not merely of the scrutiny which they're coming under and will come under, but is well aware that compliance with those international standards is the core aim. That's the significance of paragraph 2.1 of the MOU, page 2367. The point here, in this third point, is that there is no sharp division between good faith and intent on the one hand, and satisfaction of those standards to enable removal to adequate processes and safe treatment on the other. There's no such distinction in practice. It isn't just about good faith abiding by the letter of the arrangements, even if that would or might leave some area of doubt, but it's about their willingness to devote whatever effort and resources needed to abide by the commitments to deliver that sort of system. There's no sharp distinction in principle either. The predictive judgment about how a friendly state which has entered into these sorts of commitments with that crystal clear objective will act, including in ensuring that necessary resources are in place, that changes are made, that developments happen in relation to training or whatever else it may be. That calls for just as much respect, or margin if you will, just as much institutional competence and expertise in making that judgment as in relation to an issue purely about good faith. Capacity and capability are matters which Rwanda can control. And so the judgments are about the delivery of the systems in that sense, to deliver the international standards for determining asylum claims that will be fair and appropriate as intended. And to the extent that that might involve different approaches to the past, or a different way of doing things, to the way in which they traditionally do things, to making alterations to the present system, to whatever may be needed in that respect to ensure faithful delivery, then that's a judgment call. Are they going to do that? Are they going to come at this with that will? And those judgments are, therefore, it's not just good faith or intent, those judgments are judgments on which the government's institutional expertise bears for obvious reason, because they involve at heart predicting how a friendly sovereign state is going to react in the light of the commitments that it has given with a specific and clear objective that has been identified. And as you know, the government has in fact made that predictive judgment and has come to a clear view. So I do not accept the validity of the majority of the Court of Appeal's reasoning based at core on precisely that distinction, that sort of distinction between good faith on the one hand and capability or capacity on the other, using that in a broad sense. It's also very important to recognise, we submit, perhaps this should be the fourth point, it's very important to recognise before getting into the detail of the disputes that evaluation of future risk does not require the court to resolve the issues about past conduct. As the Lord Chief Justice correctly pointed out at paragraph 470, the government could not hope or realistically expect to do so satisfactorily for at least the reasons that the Lord Chief gives at paragraph 470. And we submit that it is not necessary either, not necessary to do so, precisely because of the points of principle I've just identified, and because, as the Lord Chief put it in that same paragraph, then going on in the next paragraph to cite Raymond for this purpose, and Begum, that would, as he put it, not be the correct approach when evaluating a future risk of this nature anyway. Even if one could realistically do so, and even if you were to conclude that in relation to some past incidents the conduct had been less than ideal or satisfactory, all that would do would simply be to re-raise the question whether Rwanda would actually risk deliberately or in some way inadvertently breaching these arrangements, the new arrangements. It just simply throws up that question again, and that takes you straight back to the question of judgment. So our conclusion, respectfully, on approach is first that the majority of the Court of Appeal did not pay sufficient or correct attention to those core features of the Suring analysis which go to the manner in which the court, brackets, for itself, goes about addressing the Suring test. And secondly, in relation to none of the areas on which they disagreed with the Divisional Court, was there, we submit, a proper or sufficient basis for the conclusion that the Divisional Court had been wrong, which was the appellate standard that they had to apply with all its height and rigour. One final point before coming into a little bit more of the detail on all of this, and it's a point that probably has a headline that goes plus refoulement. So it is at least to be noted that the case being advanced by the claimants is that the Article 3 Suring risk in this respect is that the systems in Rwanda will create substantial grounds for believing there's a real risk of delivering wrong asylum outcomes, A, and, underlined, B, that the result of that is that there is then a real risk where the individuals will face a real risk of ill treatment at the hands of the then receiving state if they're removed to that state. And we've dealt with that issue in our case at paragraphs 101 to 105, making a succession of points about the degree of realism of the prospect of that second thing happening. The Lord Chief Justice correctly noted that second element and the facts which raised the question in relation to that second element at paragraph 468 in the second half of that paragraph in his judgment, and he then conducted an analysis of the reality of that risk, the degree of that risk, because it all feeds into whether or not there are substantial grounds for believing. So it's not an all or nothing thing necessarily. But he then analyzes that particularly by reference to the protections in the MOU at paragraph 10, which deals with removals on or out of Rwanda. See in particular MOU paragraph 10.4, and he conducts that analysis in paragraphs 496 to 499 in his judgment. So the point of the plus refoulement point is simply to note that when you're assessing real risk overall, there is that second element. I don't make more of it than that. I wanted then to turn in a little bit more detail to the elements of the process that have been set up and that will apply in Rwanda if people are returned. And the first heading, if I may, is Rwanda's capacity. I'm using that in the strict sense. I'm very well aware that Lord Justice Underhill wanted to ensure that everyone understood that capacity could include what I've described as capability as well. But capacity, I'm dealing with numbers, effectively, at this stage, and how that is going to work and whether that will create a risk because they're going to be swamped. That's the essential point. I start in relation to capacity with noting, as the Lord Chief did, that the case is an extreme one. The contention is that Rwanda is not safe for any single migrant. And there is real force in the Lord Chief Justice's analysis at para 472 to 473 on that point, we submit. But the short and complete answer in relation to any concerns about capacity is that the MOU specifically addresses capacity and there is no reason for supposing that those specific and thought-through arrangements will not work as intended. The relevant paragraph for this purpose in the MOU, if you could just flick it up on your screens, is on page 2367. 2367. And the paragraph we want for this purpose is paragraph 3. And really, the guts of it, for the purpose of this point, is 3.2 and 3.3, as you see. So there are mechanisms in place designed to ensure that the control of the flow is secured and is properly managed, precisely to ensure that if it takes time for the system to build, enable it to take larger numbers, that time is given, and the MOU specifically addresses that. Could I invite you to add in your notes to the references for this purpose, Armstrong 1, paragraph 16, Roman 7, which deals with the backdrop to this and with the intention to control the flows and the relevant provisions in the MOU and the note verbal to that end. That's Armstrong 1, paragraph 16, Roman 7, at page 2657. And the Secretary of State is well aware that it will take time to build up Rwanda's capacity to determine the asylum claims. That is why it might be thought only a relatively small number, I think it was 47 individuals, were initially served with inadmissibility decisions. So a relatively small number designed to get to the first flight, as it were. And there is a safety valve built in if there are concerns in practice. In addition to the points I've just indicated about controlling the flow, Rwanda can, of course, ask for assistance if it considers it needs it or it would be useful, and they can always refuse to accept or decline to accept more transferees if it reaches capacity. And you will recall that the Joint Committee, when we looked at that above the Monitoring Committee, it has a role in matching transfers to capacity. The terms of reference make clear that the Joint Committee is responsible for approving both the reports produced by the Monitoring Committee covering the monitoring of the end-to-end relocation process, and also specifically for approving what's described as the indicative forecast for numbers of individuals to be relocated under the MOU. See for that purpose page 3436. Rwanda itself is very well aware that it will need to actively build its capacity and capabilities to deal with the flow through these arrangements. As one sees, for example, let's give you one paragraph reference to one of the statements that the government of Rwanda have put into these proceedings. It's the Rwandan government statement at paragraph 19, which you find at page 3209. Where they say, in addition to the several measures in place to promptly and efficiently process the claims, the implementation model of this partnership is actively building capacity. This is end-to-end capacity building across the RSD process, from the registration at the DGIE to the appeal to the High Court. This capacity building focuses on human resources and training. The NAMA is actively hiring several eligibility protection officers and intends to keep hiring as many as necessary to meet the demand throughout the lifetime of the partnership. More administrative staff are being hired. Measures are in place to ensure our RSDC holds sessions at least once a month and often as necessary. So we respectfully submit that the Divisional Court's conclusion on this at paragraph 65 was correct. And we also note, for good measure, if this does feature under capacity, it's a slightly different but related subject, that as the Divisional Court also noted in that same paragraph, I think, the UNHCR has said that Rwanda's law relating to refugees was, quote, fully compliant with international standards, that's substantive law. See the UNHCR's compilation report on asylum process in Rwanda, Universal Periodic Review, 3rd cycle, 37th session at page 4, core, that's the hearing bundle reference, 2800. And for good measure, paragraph 9.1.1 of the MOU, page 2369, makes clear that Rwanda will ensure that asylum claims by individuals are processed, quote, in accordance with the Refugee Convention, Rwandan immigration laws, and international and Rwandan standards.
Which paragraph is that again, please?
9.1.1, I think it is.
Yes.
And for good measure, I don't think it's in the bundle, but again, I don't think there's any dispute about it, but on the dualist monist issue, under the Rwandan constitution, international law takes precedence. I think it's Article 95 of their constitution, for good measure. So that's capacity in its strict sense. But then the process sequence, if I may, and again, you'll have seen that a relatively bird's-eye summary of the process from when the plane leaves the United Kingdom through to the end is conducted in a short section of the Lord Chief's judgment, but just in a bit more detail, if I may. The process itself, this is quite a big topic with a few areas within it, but the process itself is summarised and set out, I hope conveniently, in Mr. Armstrong's statement between paragraphs 45 and 54, page 2670 and following. And there is a specific note verbal dealing with the elements of that process, called the process NV, the process note verbal, page 2377, and following is the process NV, but it starts in substance at 2379, so that's where you have the note verbal dealing with the detail of the process. And it includes, just to note this throughout to make sure that we're not troubled by interpreters and language difficulties, it includes the guarantee, in effect, of the provision of an interpreter free of charge to relocated individuals whenever that might be required. And you get that guarantee both in the process NV at paras 9.1 to 9.3 at page 2382, and also specifically guaranteed in the MOU itself at paragraph 9.1.2 of the MOU on interpreters 2369. So just to go through the process, what happens when the plane touches down, if it ever does, in Rwanda. Firstly, at the outset, there is written information provided to the individual about the RSD process and the various other processes that are in place to ensure that the individual can properly participate in those proceedings. The initial information provided is dealt with in the process NV at para 3.1.2, page 2379, which provides that all relocated individuals will, quote, be informed of the procedure for making an asylum claim, for appealing a decision on their asylum claim, and what the relocated individual will be required to do throughout the procedure in a language they understand. That's stage 1, specifically provided for in 3.1.2. There will then be an orientation session, as it's called, to take place on the day after individuals arrive, in which they're provided with more detailed information about that, with interpreters available for that session, contact information given to them to make inquiries or indeed to make complaints, if that's what they choose to do. That's dealt with, that bit of it is dealt with in para 7.1 of the process NV, page 2382, and indeed in Mr. Williams' statement of the Home Office at para 32, page 2714. They're given notice of their asylum interview, which is the second stage of the process. They're given notice of their asylum interview, and they can be accompanied to the interview by a lawyer. See page 3283. That part of the process is dealt with in the process NV at para 4.4, page 2380. Lord Justice Underhill was a bit troubled by that, because he said that an interview transcript was not provided, and it was of obvious importance that it should be. That's paragraph 170 of his judgment. But as you will see from page 2380, if you go to that, if you would, on your screens, can I just invite you to look at paragraph 4.4.1 of the process NV on that point. So we submit that that interviewing process and its recording is entirely to be expected and is entirely adequate and protected. There was some suggestion, I think, by UNHCR at some point that the interview process itself was inadequate because it was too short and didn't give them an opportunity to address whatever points they wanted to make about why they left their country of origin. That was the subject of an exchange, one of these exchanges between the UNHCR concern, as it were, and the government of Rwanda reaction in the litigation, and the reference for that criticism or concern and then answer from the Rwandan government. We've got the guarantees in the process NV anyway, but that response and criticism is dealt with at 3214. The government of Rwanda effectively reject the criticism and say the interview takes as much time as necessary for the applicant clearly to explain his or her case. The interview guiding questions are set in a way that provides the applicant with the possibility to provide all information, can be invited for more interviews if necessary. So that's the second stage, the interview process, with the attendant guarantees in the process NV and that exchange. The third stage of the process is more substantial. This is the RSDC, so the first, as it were, committee, determining committee. That's the third stage. And the RSDC we submit complementary expertise from a wide range of diverse organisations. The organisations which go to make up the composition of the committee are dealt with in the statement of Mr. Armstrong, perhaps most conveniently, at paragraph 50, page 2673. And if you wanted the Rwandan government response to the composition and constitution of that committee, again, you get substantially similar points being made at page 3226 by the Rwandan government. But the individuals at this stage have all of the opportunities provided for in the process NV, if you still have that to hand, at paragraph 4.3 on page 2380. And they have, as Mr. Williams points out at paragraph 36, 715, the opportunity to make oral representations directly to the RSDC. I wanted to pick up three particular areas of concern that the majority of the Court of Appeal had in relation to the RSDC process. And the first relates to training. If you still have 4.3 of the process NV to hand.
Could you repeat the page number, please?
Yes, 2380, my lord, sorry. I seem to be working in reverse on the paragraph numbers, but the paragraph I want for this purpose is paragraph 4.2. Asylum decisions will be taken by decision makers who are appropriately trained to take a decision on asylum claim in accordance with the Refugee Convention and are able to seek advice from senior officials or external experts if necessary. So there's a specific commitment recognising this issue in the process NV at 4.2. And indeed the competency of the interviewer is a subject which is, at the prior stage, I should have referred to it, is referred to at 4.4.2.1, competent to take account of the personal and general circumstances and so on. It's not quite a training point, but it's a competence point there to note as well. So far as the evidence was concerned, there was evidence of regular internal training, first of all, in the assurance report of the 13th of June 2022, and if you want the context for that assurance report, see Mr. Williams' statement at paragraph 7. This is information gathered at various meetings and site visits that when the Home Office went out in May of that year. Page 2708 is the context. So, but in the assurance report of the 13th of June, at section 4.5, I don't invite you to turn it up, I'll give you the reference and read you what it says. 3183 is the page reference.
Sorry, 3183.
3183. It said at section 4.5, RSDC representatives regularly have training, and they confirmed DGIE have their own research team, the equivalent of the CPIT, to understand the global dynamics of country situations. These include the main nationalities that may be considered for relocation, be made available to staff and so on. And then in the assurance report a month later, or roughly a month later, of the 5th of July, and the relevant reference for this purpose is 3267 to 3268. It's recorded that in terms of new caseworkers, the GOR, that's the government of Rwanda, said that they've been building capacity through regular training with existing staff and training additional caseworkers. All DGIE immigration officers are trained to register asylum claims, conduct asylum interviews, write reports which are sent to the RSDC for consideration. DGIE training is provided internally, or they sometimes receive training from international partner countries. And again on DGIE training, see Armstrong 1, paragraph 48 at page 2672. Recording that the DGIE have received training on international protection of refugees, international law of refugees, rights-based approach to migration, to refugees and migrants, and interview skills. Also states that training has variously been provided by the Rwandan Institute of Legal Practice and Development, the ILPD, the International Institute of Humanitarian Law, and via in-house training programs and workshops. See also for this in-house training the table entitled Information Required from GOR, Government of Rwanda, which was exhibited to Mr. Armstrong's statement, question 4 and question 32 on page 32 on page 3261. DGIE interview officers have been trained on interviewing skills, and others in continuous courses will be provided where necessary. So that's internal training, refresher training, provided every year for RSDC members, as well as for officers from MINEMA. They exist as the internal appeal body, as you know, under the system, and the DGIE. See, for that purpose, the CPIN, so produced by the Home Office team, the review of asylum processing, Rwanda country information on the asylum system. See that document, para 4.7.4, and the reference there is 2431. And all of that is supplemented by training from academic institutions and various other government departments. See, for that purpose, the statement from the Government of Rwanda of the 2nd of July 2022 at paragraph 23, page 3210, which says the Government of Rwanda has also taken measures to build the expertise of persons involved in processing the claims of asylum seekers. The Rwandan Institute of Legal Practice and Development, that's the ILDP, will be providing block courses, periodic trainings, workshops on refugee law and other related laws to eligibility officers, RSDC members, lawyers, and High Court judges. And in response to the UNHCR witness statement dated the 26th of June for the purpose of these proceedings of 2022, the Government of Rwanda provided further information recorded in the bundle at 3218. A training for RSD members, it said, is also being organised and shall be facilitated by local learning institutions, University of Rwanda, ILPD, but also by institutions concerned with the RSD process, including MINEMA, MINIJUST, NCHR, and so on. UNHCR training, that has caused some controversy in the proceedings to date. Some of the evidence indicates, at least, that the Rwandan officials have attended training provided by UNHCR, and of course the overall point is that UNHCR can and no doubt will be able to do lots more to help if necessary. There's nothing to indicate that the Rwandan government would now be unwilling to receive any such help. But the two eligibility officers and one RSDC member attended training at the International Institute of Humanitarian Law in Italy. See, for that purpose, page 3248 to 9, question 10 on that document, and question 26 at page 3256. And I've given you the reference already to the CPIN para 4.7.4, which is page 2431. Two other workshops were conducted, it appears, by UNHCR in 2018 and 19, and that is referred to in a passage on page 3256. I think that's also referred to by Mr. Williams at paragraph 35 at page 2715. It's evident that the majority of the Court of Appeal placed significant emphasis on the quality of training in relation to a number of different aspects of the MEDP. And Lord Justice Underhill in particular considers that there should have been a further in-depth assessment of the nature and extent of that training. See in particular paragraph 260 of his judgment. And just to pull them together, in summary, our core response on training and to those concerns are these. First of all, it is well understood and evident that Rwanda itself well understands the assurance provided in the process NV at paragraph 4.2. Secondly, there is extensive evidence that training has occurred and that training is an ongoing process. There's obviously something of a shutter in relation to the evidence that is live before this court in this appeal, because there were, you remember the debate in the Divisional Court about what the shut-off date was, but it was effectively July 2022 when the shutters came down. But it won't surprise the court to hear that there is ongoing work in relation to training, notably with the Rwandan Institute of Legal Practice and Development, to which I've made reference already. But there is already extensive evidence, there was already extensive evidence of training through that route and others in Rwanda to get up to speed. Thirdly, there is extensive evidence that the quality and sufficiency of training was investigated and was assessed in what we submit is appropriate detail, with the result being the process NV para 4.2 that you've seen, and indeed the conclusions and the statements that I've taken you to or referred you to in the CPIN. And we do submit that, I'll come back to it when we get into the procedural issues, probably in reply to their appeal on process, but we do submit that Lord Justice Underhill's, the gravamen of Lord Justice Underhill's concern on this point does impose a far greater burden on the United Kingdom authorities than is warranted by the Strasbourg case law in procedural terms. There plainly was detailed and active consideration given to the issue of training, but the conclusions that training had occurred and would continue to occur were entirely open to the government and indeed to the Divisional Court. So that's training. Reasons I wanted to deal with next, if I may. Where a decision is taken to refuse a relocated individual's asylum claim, then written reasons will be given for that decision. Can I invite you to go back to the process NV, which you may still have live on your screens, but I want for this purpose page 2380. And you'll see that there's a sequence of provisions governing the decision-making process. Perhaps one picks it up at 4.6. Can I just invite you to read 4.6 through to the end of 4.9? So you'll see in particular on reasons that 4.8 requires that they be notified in writing of the decision that's been taken on their asylum claim, and 4.9.2, a decision will include the reasons for the decision in both fact and law. So that's the commitment that they've given. Some concern has been raised by, in particular, UNHCR in relation to past decisions where decisions are promulgated which effectively just contain the decision and don't contain more. And one would understand the concern if one ended up with that situation. But that, I respectfully submit, would not faithfully or properly comply with paragraph 4.8, even if that was all you had, but certainly with 4.8 as expanded upon in 4.9.2, which makes it absolutely clear that there have to be reasons both in fact and in law. And so one can have an argument about the extent to which reasons are adequate and so on, but the fact of the matter is that there is specific provision made for reasons to be given in both fact and law, in the process NV. So whatever may have been the position in relation to the past or in relation to past decisions, everyone is well aware that provision exists in the process NV, and the UK will expect that to be properly and faithfully conformed to. So insofar as there are continuing concerns about reasons, then can I just give you 4 short points by way of response in relation to reasons? Sorry, 3 short points, one of which I've taken you through already, which is C for a complete answer, 4.8 and 4.9. Secondly, the Rwandan authorities acknowledge that the process may require some adaptation from the current practice. See the government of Rwanda's response to the UNHCR statement of the 26th of June. That's the UNHCR statement of the 26th of June. At the page reference is 3216. Where the government of Rwanda says, after decisions are made, all applicants receive notifications of decisions. The decisions are briefly provided in the notification, and more detailed reasons are communicated to the applicant in person. Templates are being adjusted to provide detailed reasons on the notification. And you get the same point in the statement of the government of Rwanda of the 2nd of July 2022 at paragraphs 16 to 20, describing the process as it will be, page numbers 3208 to 3209, including the giving of reasons, the notification of appeal rights and process, and so on. And the third point to note is that there is, of course, as you will see in a moment, as I come to the final stages of this, there is a right of appeal. There's a right of appeal both internally to MENEMA, and there is a right of appeal on both fact and law, in effect a de novo consideration by the High Court in Rwanda. And that is of significance because it will, to put it at its lowest, encourage the provision of proper reasons so that people can see how the earlier body reacted and what conclusions it drew. But also, if the proceedings in the High Court are in effect in the nature of an appeal on fact and law with them making their own mind up, to some extent that becomes a key part of the process. So that's what we say about reasons. Discrimination is the third topic I wanted to deal with in relation to the RSDC, but it affects various parts of the process. And this is a concern that was raised by UNHCR and that caused, to put it at its lowest, a little concern in the Court of Appeal, both in relation to Lord Justice Underhill and his judgment, see in particular 156, 200 and 201, but also, in fairness, caused a little concern to the Lord Chief. See paragraph 500.
Paragraph?
500.
Thank you.
And the concern is that there might be indications of bias against or discriminatory attitudes against asylum seekers from the Middle East. That seems to be the core of the concern here. And so far as that is concerned, of course it's very difficult to, as it were, answer a negative, or to prove or establish a negative, but the basis on which that allegation was made by Mr. Botanic, who's the UNHCR official who's produced the evidence in this case, was based on statistics which Lord Justice Underhill, in fairness to him, described as being statistically frail, which involved 2 decisions in respect of Afghanistani nationals, 3 in respect of Syria and 3 in respect of Yemen. And although, of course, no one on this side of the court goes anywhere near a position of saying, well, it doesn't matter. Of course it matters. But we do submit that statistically frail is something of an understatement. We do submit that that sample size is not of a size or quality so as to render that finding meaningful, or that concern a genuine and real concern. It's just too small a sample size. The base on which a serious allegation of that kind appears to be made is simply inadequate for the purpose, is our first submission in relation to that. And we do note, and of course, no doubt anyone can say, well, they would say this, wouldn't they? But we do note that the government of Rwanda position on this issue is both slightly outraged, to put it at its lowest, and entirely clear. Their position is that their law does not include any discriminatory provision, and they have attached to that first response a table of statistics of rejection and approval rates according to nationality, which it would appear do not bear out the bottleneck statistics. See, for example, page 3236, and in particular the table at 3441.
Could you have those page numbers again, please?
Sorry, my lord, yes, I'm going too quick. 3236,
Yes.
and the table at 3441.
Thank you.
And they then point out that in their response to the UNHCR statement of the 26th of June, they point out at page 3217 in that response, I quote, Rwanda strongly respects the principle of non-discrimination for any asylum seeker who demonstrates a well-founded fear of persecution on any ground will receive protection. And we do note, moving from the government to the Rwandan National Commission on Human Rights, they were asked about the treatment of non-Rwandans, generally not in this specific context, but they were asked about the treatment of non-Rwandans. That's the Rwandan National Commission on Human Rights. And they noted, see page 2636 for the interview note, I quote, if there is an area NCHR has not received any complaints on, it is this one. Rwanda society receives everyone anti-discrimination laws and the Constitution. Discrimination here is a crime, has its roots in our history, and so on. And we also note that the details are disputed. I said that the first problem with the basis for this serious allegation was too frail to bear the weight placed upon it. But even at the level of the detail of those individual cases, there is a serious dispute, it appears, between Rwanda and the UNHCR. And the government of Rwanda has provided its own table of decision-making, as I indicated earlier. See page 3440 and 3441. And Rwanda has provided some explanation for those decisions. See, for that purpose, Armstrong at paragraph 89, page 2684, so paragraph 89 of Armstrong 2684, and see the government of Rwanda's statement of the 2nd of July last year, paragraphs 12 and 13, page 3206.
Could you give me again, please, the reference before 2684?
The reference before that was to 2636. That's the Rwandan National Commission on Human Rights, that one. 2636, my lord.
And I think you also referred to 3440 to 3440.
I did earlier on, and I was doing it again, as it were, but that's where the table of decisions was.
Yes.
Yeah, that's the nationality one. But my lord, yes, that's the That's the answer, and we'll get to it when we get to the allegations of not understanding refugee convention law and turning people away at the airport and all of that. But it is to be noted in this respect, in relation to discrimination, I park for this purpose the issue as to whether or not it's a good thing or a bad thing in refugee convention terms, but the government of Rwanda notes in their response that the reason that people were refused or turned away was because of forged passports or deception. Now, whatever else that may be, that isn't an indication of discrimination. That provides a substantive reason, maybe a bad reason under the Refugee Convention, but it provides a substantive reason which is not discriminatory for the treatment of those individual cases. So the overarching point is that even at the level of the individual cases, there is a genuine question, back to the point that the Lord Chief repeatedly made, which is, how on earth is anyone meant to resolve these to any extent satisfactorily? So that takes me to the fourth stage. Those were the three core concerns I hope dealt with in relation to the decision-making processes, particularly of the RSDC. And that takes me to the final stage of the processes, which are the rights of review and the right of appeal. That are embedded in these arrangements. Just to take those through and give you the detail. I'm sorry, I said it might descend into a dull reference-giving exercise, but at least give you the main points as we go. Individuals will be notified in a language they understand of the right first to appeal to MENAMA, that's an acronym, against the refusal of asylum by the RSDC. So you go RSDC, internal appeal to MENAMA, first of all, and second, to the High Court, should MENAMA, on the internal review, dismiss that. And you get that process built in from you get that process in particular, first of all, flagged in a passage you've seen already in the process NV, page 2381, at paragraph 4.9.3. That's the provision that tells them that they've got to be, that provides that they have to be notified not merely of the refusal with the reasons in fact and law, but also that they're able to appeal it and providing an explanation how to do that. That's 4.9.3. And then you see asylum appeals dealt with in paragraph 5, which I'll come to immediately. But 4.9.3 is the start. And as you see, individuals then have the opportunity to make oral and written representations to MENAMA at an appeal hearing, and any legal representative will also have an opportunity to make submissions. See paragraph 5.1 and following on page 2381 if you have that still open. Can I ask you to cast an eye down that paragraph in its totality? So you'll see, so far as the High Court is concerned, that in effect the jurisdictional provision in the process NV is the one at 5.4, which I referred to earlier on. The court will be able to, that's the High Court in Rwanda, will be able to conduct a full re-examination of the relocated individual's claim in fact and law in accordance with Rwandan rules of court procedure. And for good measure, if you go on to the, if you go back to the MOU, which this is reflective of, and you go to paragraph 9.1.3 on page 2369, so 2369, I should have done it in reverse order, but 2369, paragraph 9.1.3 of the MOU, if a relocated individual's claim for asylum is refused, that relocated individual will have access to independent and impartial due process of appeal in accordance with Rwandan laws. And as Mr. Mustard pointed out in his Foreign Office statement for these proceedings at paragraph 13.1.3, page 2745, the Rwandan constitution itself provides for an independent judiciary. And my lords, it's to that topic that I wanted to come next. The Court of Appeal were evidently troubled by the independence and impartiality of the Rwandan judiciary. Can I give you the references, as far as that is concerned, to the 3 judgments in the Court of Appeal that deal with this part of the case? The Master of the Rolls dealt with it principally at 95, 100 and 104. Lord Justice Underhill deals with it at paragraph 217 to 222. And the key paragraph, perhaps, in that little section of his judgment is at 221. And the Lord Chief Justice deals with it at paragraph 513 through to the end of paragraph 515. It is to be noted at the outset in relation to this concern, as the Lord Chief did at paragraph 510, that despite the scale and range of concerns raised by UNHCR, it says little, if anything, of substance about this issue in relation to the High Court. It does not make any positive case that judicial independence, or lack of it, perceived lack of it, in effect flaws this internal Rwandan protection. The principal basis for concern on that front is the Divisional Court's judgment in the Netsirayu case, which starts at page 5849. And that is a very long decision of the Divisional Court in the context of extradition. And I'll probably come back to that, if I may, after the short adjournment. But it's a long case dealing with the possibility of returning to face trials of murder, individuals who were involved on, for this purpose, the wrong side of the tribal divide, as it were, in relation to the genocide and the difficulties that Rwanda experienced at that time. And so there was a very, very specific and special context which led to the concerns of the court there. And ultimately, my submission in relation to that case is going to be that even in relation to that context, with its obviously incredibly fraught context and a difficult set of issues because of the way in which history had played out, even in relation to that, the conclusion of the Divisional Court was not that even in the context of trying crimes of that kind, the independence of the Rwandan judiciary, as it were, was a busted flush and could not be relied upon. It was that because of the concerns that might be perceived to arise in that very special context, there was a particular and overarching need for there to be proper protection in terms of legal representation of individuals who might face those charges in the Rwandan courts if extradited, and those were not present. So that was in essence the reasoning of the Divisional Court in that case.
So were these Hutus accused of killing Tutsis
Yes.
during the genocide?
Exactly. So that's what I meant by the wrong side. I don't mean that in any way to be flippant, but you see the point. And we respectfully submit that that does not provide, even on its face, and even in accordance with its own reasoning, a basis in effect for discounting as non-independent the entire High Court of Rwanda. But there's no proper basis for that sort of finding or that sort of concern. As I say, it was a special context, and on its conclusions didn't reach that finding anyway.
Just to help me, how many judges are there in the High Court of Rwanda?
Don't know. Can I check?
See, the entire High Court of Rwanda, one could imagine 10, 50, 100.
Don't know. May I check and get back to you? I didn't mean that to sound.
Well, it does sound like that, but I just wanted to get some figures on it.
I'll ask and make sure you've got that. But the concern, the particular concern in that case, is the point that the people who are alleged to have been involved in the genocide in that case, and the people who might be trying to mandate the government, there were strong concerns about animus, effectively.
And the reference to the case, Sir James?
The reference to the case, it starts at page 5849.
Thank you.
I'll come back after the short adjournment if I may and just give you the relevant paragraph number so you can see exactly what that context and concern was. But there's no equivalent position here. There's no reason to suppose, it's almost like the point I made in relation to Othman earlier on. There's no reason to suppose that the government of Rwanda have got a bias against these claimants or would want their asylum claims to be rejected or would in some way be tempted to reach a different conclusion on the basis that the RSDC or MINEMA or anyone else had reached a particular decision in a particular case. That appeared to be the core concern of Lord Justice Underhill, and we submit with the greatest respect that that's a fanciful concern. And indeed, it's a fanciful concern, not least for the reason that the Lord Chief was interested in at paragraphs 513 to 515, which is that everyone concerned will know, because they are public, that this full-blown appeal on fact and law, full re-examination of the case on fact and law by the High Court, is one of the specific things to which the government of Rwanda has itself committed in the MOU and in the process NV. But there is no reason to suppose that the High Court will not do precisely that which one would expect them to do and which the government of Rwanda has committed them to do, is to look at the individual facts on their particular merits and to reach a view on it for themselves. That independent role for them, look at it for yourself, fact and law, is specifically a task and a responsibility conferred by their own government upon them. Now, that may be a convenient moment.
Yes, yes, certainly. We'll resume at 2 o'clock.
Great. You'll see the cause for concern in that specific context, but in the end, neither agreeing with neither of the more extreme propositions. They're not independent, they are independent. Somewhere in between, there is a concern. That was the view they came to with a bit too sanguine conclusion in 239. And the significance of that conclusion is then reflected in 240, where they say, and that puts added weight and emphasis on the need for effective representation under Article 6 with trial lawyers and so on. And that can't be guaranteed, effectively, was the conclusion. So that's what I wanted to say about judicial independence. I respectfully submit there isn't a proper basis in the materials before the court, still less by inference from this case, that there is, as it were, reason to discount the High Court in Rwanda as a proper and effective safeguarding measure referred to and relied upon and provided for in the MOU in the manner that you've seen, and in the process note verbal, and that in essence the Lord Chief's conclusion on this issue is correct. I wanted to pick up two final general areas on the process and the sequence of the process of decision making in Rwanda, and one of them is legal assistance, on which as you know, the Court of Appeal the majority were somewhat concerned, but can I pick that up? Access to legal assistance, we respectfully submit, is guaranteed appropriately and properly in the MOU and the note verbal. See, for that purpose, the MOU at paragraph 9.1.2 2369 is the page number, 2369 9.1.2. Each relocated individual will have access ... to procedural legal assistance at every stage of their asylum claim, including if they wish to appeal a decision made on their case. And then the detail of some of that is dealt with in the process note verbal at paragraphs 5 in part and then 7 to 8 in part. So 2381 is paragraph 5 of the process NV. And you'll see in particular paragraph 5.2, second sentence on page 2381. And 5.5, so that's relating in effect to Menema and the Menema review or appeal and the High Court appeal. And then
sorry, just not, was the MOU dealing with the initial interview before the RDC as well?
Yes, but I don't think deals specifically with this. I'm not sure the MOU dealt with it other than in general terms. The process NV comes back to legal assistance, at least at paras 7 and 8. So 5 deals with legal assistance and what they can do and what they're entitled to do at the stage of appeal. And the earlier stages are dealt with, I think, in 7 and 8. Well, 8 deals with legal assistance at appeal as well. But 7, you see.